J Group Holdings versus Azar Stafford. They didn't get to say.
Good afternoon, Your Honor. Plaintiff Anthony may not be appearing on behalf of plaintiff.
Good afternoon, Your Honor. Azar Stafford.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to all reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this instance.
The problem is, and I don't. You've not received any documents that you attempted.
Nothing since the original delivery that I placed on the record.
Buckle up, guys. Today we're diving into a heated child support case where the father is fed up and the mother is ready to move states. From the jump, the judge's expression says it all. This isn't going to be easy. As the father claims he's overpaying while juggling other responsibilities, the tension builds fast. But just wait, because what mom reveals next flips the courtroom dynamics on its head.
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court. We did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
All right, guys, things are getting spicy. The mother reveals she's planning to move to Florida with the kids, and suddenly it's not just about money. It's about distance, schools, and parental rights. Judge Vonda doesn't waste a second. She zeroes in on whether this move is even legal. You can feel the dad's frustration boiling over, but the judge stays calm and calculated. She smells drama and possibly manipulation.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes,
My sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them.
GIS today and answer a motion to dismiss was filed.
That was.
Not by me, Your Honor.
Yes, okay, I see that. But that was not the original.
Hold on tight, because now the father's dropping bombshells. He says he's not just supporting one household, but 3. The courtroom goes still. He's got receipts and emotions to match, calling out how he's doing his best while being stretched thin. Judge Vonda leans in, trying to get to the truth without getting pulled into the blame game. You can feel the judgment brewing, and the stakes are climbing fast.
I've not seen that.
Service on here. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
May I show this to you?
No,
This,
you did the same thing.
no. This notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
This next part is where the courtroom starts to shift. The mother throws in her counterpunch, painting herself as the sole provider and primary caregiver. But Judge Vonda doesn't just accept what's said. She questions everything. Is this a strategic move to avoid accountability, or is she genuinely overwhelmed? The father's eyes say it all. He's had enough. It's a tug of war, and no one's backing down.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to...
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney that's licensed to practice to do this.
Okay.
Now this is where it gets real. Judge Vonda starts running the actual numbers. And when that calculator hits the desk, you know the excuses won't matter anymore. She calls out the truth behind both their claims, and suddenly both sides are scrambling to defend themselves. It's no longer about who's loudest, it's about who's got the math to back it up. And someone's about to take a major L.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly, this is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy, and I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started. If at all the court would go along with us, let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was...
All right, the courtroom is heating up. Judge Vonda questions the Florida move hard, and when she brings up the father's visitation rights, the tension cuts like a knife. It's not just about support anymore, it's about custody and control. The judge's words are deliberate and loaded, showing she's not here for emotional manipulation. One wrong answer, and the whole case could flip. Buckle up, it's getting intense.
Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of
No, you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy. Okay? This loan shark and his attorney are trying to,
Are you almost done?
yes,
Good.
to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property.
This one's a game changer. Judge Vonda exposes inconsistencies in both their stories. She hits them with cold facts, pointing out what the law says, not what they feel is fair. You can almost hear the air leave the room. The father looks stunned, and the mother? She's scrambling for justification. It's a reality check in real time. This isn't about winning. It's about doing right by the kids. And here's the final stretch. Judge Vonda delivers the verdict, and it's clear she's siding with what's legally sound, not emotionally charged. She breaks down exactly what each parent owes and what rights they're entitled to moving forward. It's a powerful reminder that court isn't about personal beef. It's about structure and justice. If you found this breakdown helpful, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.